United States Court of Appeals, Division 1 is now in session.
Thank you. Good afternoon. Please be seated. This is the time set for oral argument in our cause number CACV140290 in the matter of John L. Bedway versus Rooney Ferguson, MD, and his professional corporation. Each side will have 20 minutes to argue. Appellant, if you'd like to save time for rebuttal, we'll let you manage the clock. On the podium, we are recording the audio. If we need to listen to this, there's also a videotape. In a few days, you can go to YouTube and watch yourself, and if you like, you can put it to music and have fun with it. We have read the briefs, we've conferenced this matter. We think we have an understanding of the issues that have been presented, and with that, Mr. Lloyd.
Thank you.
Good afternoon. I want you to imagine that you represent Colonel Sanders, and you've brought a lawsuit against Henny Penny.
I do. I try to eat at Colonel Sanders every chance I get. So,
And you walk into a rural courthouse, and you sit down, and the judge tells the bailiff to bring in the potential panel, and in walk a bunch of potential jurists, including about a dozen chickens and about a dozen strict vegetarians. And when the judge asks them if they can be fair and impartial, they all say, "You bet." And that's kind of the situation we encountered a couple.
we like that issue as well as the closing argument, but what's really on our mind is the judge rulings with respect to limiting the testimony of Dr. Williams.
I'll talk to that
So
next.
please, yes.
Dr. Williams is a orthopedic surgeon who testified that as an orthopedic surgeon, he reads regularly MRIs, gets in disputes with radiologists because he believes he can read them as well as they can, and he thinks it's important in his practice to know when a radiologist says something and what they mean. In this case, the standard of care required that if a orthopedic surgeon suspects that there is a distal biceps tendon rupture or a tendon rupture, that they order an MRI to see what the nature and the extent of the rupture is. If it's up by the shoulder or if it's down by the elbow, it's a big difference in what has to be performed. And so Dr. Ferguson ordered the MRI, and when the report came back, it was...
So far, so good at that point.
Yeah, so far so good. He orders the MRI, the report comes back, and the report basically is a little ambiguous, if not vague. It says there's a distinct rupture, and then it says, but it's an incomplete rupture, and then it says that the tendon is quite circuitous in nature. Well, the tendon's normally pretty taut, even when you're relaxed. And that should have been enough indication, as Dr. Williams testified, for Dr. Ferguson to have investigated further. But Dr. Ferguson admitted he never read the MRI report.
Which portion of the report are you saying should have triggered Dr. Ferguson to have viewed the films?
Well, he didn't have to review the films. That's not our point. He had to have at least read the report, and that would have triggered him a phone call to the radiologist. What are you talking about? This doesn't make sense.
Are you saying that Dr. Ferguson testified that he never read the report?
He did. He never read the report.
Wasn't it read to him in the hallway?
He said that his PA, physician's assistant, told him what the report said. We don't know what the PA actually told him. But he never read the report. Dr. Ferguson, or Dr. Williams, who was our standard of care expert as well as our causation expert, read the images, had the images, they were admitted into evidence, they were part of the record, and he was prepared to show the jury on some large blow-ups precisely where this rupture occurred and that it was a complete rupture. When he was ready to do that, ready to offer that opinion, defense counsel objected and says he's not a radiologist, he's not qualified to offer that opinion. That was the only objection.
Well,
And the judge sustained it.
Didn't defense counsel also argue that, hey, in the deposition, he acknowledged that the standard of care only requires the orthopedic surgeon to review the report? No, or perhaps it was stated the standard of care allows the orthopedic surgeon to rely on the report. So that was part of the argument made
Right.
by defense counsel, I think, wasn't it?
That was part of his argument, but Dr. Williams said he was required by the standard of care to have read the report, and if he had done that,
Read the report.
it would have triggered in his mind a question that would have mandated that he follow up on it.
Yeah,
And that's where he didn't do it.
Okay, I see what you're saying. I thought that there was the equivalent of reading the report. In fact, I thought at some point he initialed the report.
He may have initialed it. I don't think he did. But he testified at trial and admitted at trial. That's very clear. He did not read the report. He never looked at it.
The report.
The report.
Okay.
And obviously, he never looked at the images either.
Right.
And so that's the big issue. The excluding Dr. Williams from offering that critical testimony was extremely prejudicial to our case because it showed that had he done what he was supposed to have done, he would have discovered that there was a complete discal biceps tendon rupture, and that mandated immediate surgery to repair
Are you
it.
saying that he would have discovered, in essence, that the radiology report was incorrect?
He would have discovered, he would have asked for a follow-up and discovered that the report was incorrect, or made a phone call to the radiologist and discussed the matter further and then investigated it. There was no further investigation
I
done.
guess what I'm trying to, think about what was known at the time.
Mm-hmm.
He had thought he palpated a some residual of a tendon there.
Correct.
He gets a report that does say definite rupture, but then it says in the next sentence, it is an incomplete rupture.
And then in the next sentence, that it's circuitous in nature, which makes no sense.
Yeah.
If it's a complete rupture, why would it be circuitous in nature?
I guess I don't know enough to know whether it can be stretched and still not completely broken, you see, which might allow it to become circuitous. I don't know. I don't know if there was any testimony on that.
Well, as I said, Dr. Williams was prepared to show the jury this loose tendon, and it was circuitous.
Yeah.
It was clearly off of the bone.
So, are we dealing with a disclosure issue? In other words, was there a need for something more to have been disclosed by your side regarding the inaccuracy of the report?
Dr. Williams testified in his deposition, so they had ample knowledge, that in his opinion, after reviewing the films, it was a complete rupture. It was off of the bone. The defense knew that, and they knew that's where we were headed with it.
How does that square with his testimony that the orthopedic surgeon can rely on the report?
He can rely on the report if he read the report. He didn't even do that.
Whether he read it or somebody told him what it said, it was consistent with his clinical finding of having palpated a residual, I'm using the word residual, palpated a tendon. And then the report comes back and uses the two rather important words, incomplete rupture.
And I guess the problem is that if first of all, Dr. Ferguson agreed and admitted that when you have a rupture, there's swelling. In fact, the MRI report showed that there was a lot of fluid. It's swelling. And Dr. Williams testified, both in his deposition and at trial, that swelling can give you a false reading where you think there may be a tendon attached, and it really isn't because it's so swollen, it's tight, it's still basically feels like there's something there, and that a prudent, reasonable orthopedic surgeon would investigate the matter, especially when they got that report. That was our whole issue in the trial, was that he didn't even read the report. If he had read the report, that would have triggered something in his mind, every reasonable orthopedic surgeon would have thought, this doesn't make sense, I need to investigate it further. And of course, there was testimony from Mr. Badway that the muscle was jumping up on, was balling up. That was disputed, but that was the testimony that he had. And we had a picture. Unfortunately, it didn't show very much. It got into evidence, but it wasn't professionally taken to show that. So that's the issue on that. That's our argument on that issue.
On the report, but weren't you able to present evidence, through Dr. Williams, that Dr. Ferguson should have reviewed the report? You were able to present evidence on that point.
Yes, we were. And had he done that, we were going to show that had he done that, he would have discovered that it was a complete rupture, and he would have done appropriately, taken him to surgery.
Had he read the report, or are you talking about the films themselves now?
Now, if he had read the report, that should have triggered in any reasonable orthopedic surgeon a investigative mode. We need to find out what's really going on, and had they pursued it, they would have more than likely discovered that it was a total, complete biceps tendon rupture, which mandates immediate surgery. That was the issue.
So other than for this issue, what would the MRI images were going to be used for what? Solely for this purpose?
Correct.
But there was no objection?
No, the MRI images were stipulated into evidence. We had enlargements made of them in different slides. The doctor was standing there prepared. The defense attorney knew what he was about to do. He had seen them, and just as he started to offer testimony, there was an objection, and the only objection basis was, well, he's not a radiologist. He can't offer those opinions. And I think that was error. It's clearly wrong. He's not there testifying as standard of care of a radiologist. He's just simply saying, this is what I interpret it, and had he followed up on this, he would have discovered it as I discovered it. That's the issue.
Well, let me ask this, and I don't know if the record shows this. Do orthopedic surgeons use radiology film in the course of their surgery if it's required?
Well, standard of care is you take an MRI when you suspect there's a distal biceps tendon rupture. You do an MRI, and you do it to find out the nature and extent of that rupture.
Okay.
I really think this first issue about forcing us to decide whether people who are obviously hostile, that you don't have that down here in Maricopa County or in Pima County. But in some of these rural counties,
Well, we got lots of hostile jurors who come to court, and don't want to be.
I know, but they're not all patients of a
Oh,
doctor,
that's-
and that's the issue. Is I think that clearly I couldn't find a state case in Arizona, so it's probably an issue of first impression. But when you've got a rural county where everybody knows the doctor, or a substantial portion, they've got an interest. The relationship between an attorney and his client is precious and is protected, but the relationship between a doctor and his patient is much more intimate. And there's got to be some sort of a loyalty there, some sort of interest that person has. And to force us to choose between people that hate lawsuits against doctors and patients of the doctor, I don't think that was fair. And we asked that.
Counsel, you're assuming that's a favorable relationship, though, for everyone. I understood that there was one juror that responded and say that I didn't have a favorable experience.
Right, and the judge struck him for cause and left all the rest on.
I thought the judge struck 2 who had been patients of Dr. Ferguson and left on 3 whose family members had been patients of his.
I think there was only one, is my recollection. There was one gentleman who had had a bad experience. All the rest were left on the panel, and we had to make that choice. We didn't have enough strikes.
So how many of those, how many were there left on? 3?
3 ended up on the jury panel, including the 4-person who had been in his office 6 weeks earlier.
That's because 2 of the jurors had.
So you didn't use any of your strikes on the Ferguson patient?
Oh, we used some on them. There were 7 of them.
How many strikes did you have?
I think we had 5. We used some on them, but then we've got this group over here that we could tell that wasn't going to be a good thing. And so I just think that's something that's inherently wrong.
Well-
And the Edison case, I think, or Eddington case, I think, was pretty well on point.
What direction should we give a trial judge in trying to formulate when the juror says, Judge, I can listen to the evidence and I can listen to your instructions and I can be fair and impartial, even though this parent had a child see the doctor 6 weeks earlier, 6 years earlier, whatever the case may be? Because it happens all the time in the criminal realm. My father-in-law is an FBI agent, and I like him, and he doesn't talk a lot, but I can be fair and impartial. And there's at least the presumption that, it's not a strike for cause.
Well, that's a little different, though, when you've got a personal relationship with the defendant. I think that it's like the analogy, if it was a courtroom full of police officers and it was one of their own that was investigating officers, they could all swear and say, hey, we'll be fair and impartial, but the defendant certainly wouldn't believe that. And in this situation, I think when you've got 70 or 80 people or whatever the number that were called in the panel, I think the prudent thing would be to if they've got a close relationship with that physician, either them or a close member of their family, then I think that shows that they've got an interest in and to be fair and impartial, they ought to be stricken for cause. They have an interest. People have an interest. They choose their doctor. And whether they want to admit it or not, you defend your choices. And they defend their choices. I chose that man. I'm going to support him. And that's, I know we don't have that down here or in Tucson, but we've got some of those problems in some of the rural little counties. I want to reserve a little bit of time. Is there any other questions that you?
Yeah, I have one question. In the transcript where the Dr. Williams issue was addressed by the court and by counsel, you made reference to the affidavit of Dr. Williams, which I take it is the affidavit that's filed at the time the case is filed.
Yes, and then we filed one in connection with a motion for new trial, too.
Yeah, I'm not.
Yeah.
We have the later one. Our record does not seem to have the first one. It was listed as Exhibit 19 in the pretrial, as best I can tell, but I'm guessing it wasn't admitted, and therefore it and a whole bunch of others were probably released out.
It wasn't admitted. It was
If you want us to have it, or if the other side wants us to have it, somebody ought to file a motion. If not, we don't. I'm just telling you, we don't have it.
I didn't realize
You could
that.
supplement the record because we don't know if it was not filed appropriately, and many times numbers get backwards, and people file it in 2-3 as opposed to 3-2. But unless there's a disagreement that about its filing, then you may want to together file a stipulation to supplement, and so that we can look at it.
Okay.
Since you at least were showing it to the court as you were arguing your position.
Yeah, preliminary affidavits of experts are normally not filed, so it's probably what happened, and I will file a motion and get it in front of you.
Thank you.
Thank you.
Skilbright.
Thank you, Your Honor. Eileen Gilbride for the defendants. First of all, I'd like to express my appreciation to the court for changing the oral argument upon my motion. I really appreciate it. I'm also going to change the order of my issues since the court seems to be interested in the Dr. Williams issue more than the juror issue or the other issue. But I'll start with the witness issue. Now, plaintiff, in his briefs at least, seems to go on about how Dr. Williams' opinion about what the MRI showed, the MRI film, should have been admitted because under Rule 702, because Dr. Williams felt qualified to say what the film showed. But that's just not the issue here. The issue is relevance. Whether Williams' opinion about what the MRI showed was relevant to any issue in the case, and if so, whether the law would have allowed him to testify to what the MRI film showed. Now, his opinion of what the MRI film showed was not relevant because plaintiff never argued that Dr. Kavanaugh, the radiologist, misread the film. There was no issue.
I understand, excuse me for interrupting, I think I understand, and I suspect we understand what you're arguing here.
Yeah.
But, although possibly not. But it seemed to me that from the brief and from what I have read and from Mr. Lloyd's argument as well, he's not saying, oh, you know, the thrust of Dr. Williams' curtailed testimony or excluded testimony was that the radiologist screwed up. He was prepared to talk about what he thought an orthopedic surgeon ought to be doing, and not a radiologist.
That's not what the argument was about at trial. The argument was about at trial, and what I understand the plaintiff to be arguing in his brief was that Dr. Williams should have been allowed to testify that he read the MRI film differently from Dr. Kavanaugh. He would have read the film to show a total tear, a complete tear.
I think at least I understood, I don't know for sure that I was correct, but I understood Mr. Lloyd to be arguing, in fact, that yes, part of what you said, but more, to be arguing that based on the report, there should have been more follow-up.
Right.
An orthopedic surgeon should have looked at the films or called the radiologist or done something more, and that Dr. Ferguson didn't, and Mr. Bedway and his counsel didn't get to put that evidence in.
No, I think Dr. Williams did testify that there should have been more follow-up. And Dr. Hartzler, our defense expert, testified, no, it was not, the report was not ambiguous, and there didn't need to be more follow-up because the report was completely consistent with the physical palpation of the tendon.
The clinical findings.
Yes. And so if there was a difference between the clinical findings and the report, sure, then that would have required follow-up. But because there wasn't, there didn't need to be any more follow-up.
I'm not sure that it matters too much or very much what Dr. Hartzler said here, because the issue is the curtailing of Dr. Williams' testimony. But
right.
Did Dr. Hartzler talk about, do you happen to remember the circuitous route description in the report? I'm
not sure if it was Dr. Hartzler or Dr. Ferguson. One of them testified about it and said, well, because of the fluid, it could have felt circuitous. But I do not recall one line of testimony in the evidence where Dr. Williams said that the swelling can give you a false positive or a false inclination of what's happening here. Dr. Williams said, yes, it can be a little difficult, and I think Dr. Ferguson might have testified this too. With the swelling, it might be a little difficult, but neither Dr. Ferguson nor Shane Walker testified that they had difficulty palpating the tendon, that they could feel it. This was consistent with the MRI report, and therefore there was no ambiguity. My understanding of plaintiff's argument in the briefs, and I've read them over again recently, yesterday and the day before, was that Dr. Williams was prevented from testifying to how he would have read the film only. He was not prevented from testifying that Dr. Ferguson erred in not reading the actual report. He was able to testify. Of course he should have read the report. If you're going to order a report, you have to read it. He did testify to that. And Dr. Hartzler said, yes, you should read the report. But when Shane Walker went over it with him in the hallway, that met the standard of care. That constituted reading the report. And that's in Hartzler's testimony at page 124.
Let me sort of approach one question this way, please. I think I hear you saying that the other side has not argued that Dr. Williams is going to say that under these circumstances, the standard of care required the orthopedic surgeon to do more. But I think that's what they disclosed.
They did, what wasn't disclosed, and this is where we have the disclosure problem, because plaintiff has misunderstood what was not disclosed. What was not disclosed is any opinion by Dr. Williams or any theory by plaintiff that the MRI film was misread.
Well, but they weren't suing the radiologist.
Exactly, and that's why Dr. Williams' opinion about what the film would have showed if he had read it was not relevant.
Well,
Because
I'm having trouble following you there.
Okay.
Because Dr. Williams is an orthopedic surgeon.
Exactly.
He's talking about what an orthopedic surgeon ought to do.
Exactly, and he was allowed to testify to what Dr. Ferguson should have done. He should have read the report. He should have followed up. The report was ambiguous. He testified to all of this.
I think it was also his opinion that he and other orthopedic surgeons have experience in reading reports, and he would have read it, and in his opinion, Dr. Ferguson should have.
No,
Read,
his
I said report, I meant films.
film, yes.
I meant films
Yes.
or images.
And the evidence was, and Dr. Williams, Dr. Ferguson, and Dr. Hartzler all agreed that it was completely within the standard of care for Dr. Ferguson not to read the film, not to look at the film, but it was completely okay for him to read the report and to rely on Dr. Kavanaugh to read the film. He's the expert on looking at the films. That's why Dr. Ferguson had an MRI.
But wouldn't it have been relevant, let me approach this way, wouldn't it have been relevant to the jury in determining what was the applicable standard of care? To hear Dr. Williams say, in my view, the orthopedic surgeon should have looked at the film, and here's what I saw on it.
He didn't say that. It wasn't his opinion that Dr. Ferguson should have looked at the film. It was his opinion that it's completely okay to rely on the report. He never said Dr. Ferguson should have looked at the film. He never said that. That was not his opinion. That's the opinion that wasn't disclosed. No one ever said Dr. Ferguson should have looked at the film. Every medical witness who testified agreed that it's completely fine for an orthopedic surgeon like Dr. Ferguson to rely on the report of the radiologist. That's why you have a film. That's why you have a radiologist, because...
Yeah, excuse me for interrupting, but I'm having trouble following because I'll share this with you. I've got one of the disclosure statements here. I think it's one of the ones that is at issue. And it says Dr. Williams will testify consistent with his affidavit, and it says later is expected to testify consistent with his deposition. And it says specifically Dr. Williams will testify that it is his opinion that Dr. Ferguson should have reviewed the MRI images on January 31, 2011, and had he done so, Dr. Ferguson most likely would have discovered that the biceps tendon was ruptured. Dr. Williams will testify that the standard of care, and I'm sure he's talking about for an orthopedic surgeon, not a radiologist, required a ruptured biceps tendon to be repaired surgically, preferably within 14 days, etc. And some other things.
Is that the disclosure that was attached to the reply brief? Because that was
I'm not sure, but it could well be.
stricken from the record. It was stricken as not being admitted below. There's an order striking.
Oh, well, it's found within the record as one of the supplemental disclosure statements.
Disclosure statements aren't filed with the court, and if there was only one in the record. Well, not in the record.
Well,
there was only one before the court. It was attached to the reply brief and stricken by an order
As I recall,
from this court.
As I recall, this is very, very much tracks what Mr. Lloyd was arguing when he and Mr. Skelton were arguing this with the court on December 10, I think it was.
That order was dated November 12th, 2014.
But along the lines of what Judge Campbell was saying, Mr. Lloyd said, Your Honor, we are not attacking the radiologist. He's just explaining that that the surgeon has an obligation to look at the MRI. Dr. Ferguson never looked at the MRI. So are we
They're
saying?
talking about the report. Dr. Williams, all of the medical,
But the report that came in, he was able to.
Yes.
He was able to criticize that. But why
Yes.
wasn't he able to go ahead and say he also should have looked at the MRI? And that's what.
because he didn't testify to that. And that might have been what he argued, but Dr. Williams didn't testify to that. He testified, and it's in my brief. I don't have the page number. I can get it, but it's in my brief where all three of the experts or the medical witnesses testified that it was within the standard of care for the doctor to rely on the report. He did not have to look at the films. He's not an expert in looking at films. That's why he has the radiologist look at the films, for that very reason. And he's entitled to rely on that report by the radiologist. Now, if plaintiff had said, Dr. Kavanaugh, you misread that film, and your report is wrong, that's different. Then you have to have a radiologist come in and say, Dr. Kavanaugh, any reasonable radiologist would have read that film differently.
But why do you need that when a orthopedic surgeon who has to look at them from time to time to determine whether to do surgery can look at them anyway and is trained to do so?
Because he didn't. Dr. Ferguson says, I rely on the report. I'm not the expert at looking at the film. And everybody said, Dr. Williams, Dr. Ferguson, Dr. Hartzler said, that's fine. You're a generalist. You're an orthopedist. We're not going to hold you to the standard of care of looking at the films. They didn't testify. No one testified that general orthopedists like Ferguson look at the films. They testified it was within the standard of care to rely on the radiologist's report. And since that's the case, Dr. Ferguson didn't look at the films. He didn't have to look at the films. It wasn't standard of care for him to look at the films. Then why do we care about how Dr. Williams would have read the film? Everyone said it was fine for Ferguson to rely on the report. That's what he did. So Dr. Williams.
Part of that, I understand that Dr. Williams, there's a 3 or 4 question and answer sequence in his deposition where he seems to acknowledge that, but elsewhere he says, this report would cause me, and I'm paraphrasing poorly perhaps,
Right.
this report would cause me to follow up.
And he testified to that. He was not precluded from testifying to that. And Dr. Hartzler said it wouldn't cause me to follow up because it was consistent with the physicals. So you have an issue for the jury. Should you have followed up? Shouldn't you have followed up? Williams says yes. Hartzler says no. The jury said no liability. There's no relevance to Dr. Williams trying to attack how Dr. Kavanaugh read the film. Because it was Dr. Kavanaugh who looked at the film, not Dr. Ferguson. And everyone said it was fine for Dr. Ferguson to rely on the radiologist report. If it was fine.
Kavanaugh was not listed as a non-party at fault, was he?
He was not. No, he wasn't sued. We think he read the film fine.
Sure.
And he had a report. He read it. Here's the report. Dr. Ferguson said, thank you very much. I rely on this. The experts say, good, you can rely on it. That's why you get radiologists to read reports, because they're the expert.
Is it part of your position, or perhaps at trial more than here, but I'll ask anyway, that for an orthopedic surgeon who is a generalist, as I gather Dr. Ferguson is, that it might be one thing if we were dealing with ordinary plain films, x-rays, but here we're dealing with an MRI, and here we're dealing with MRI of the elbow, which I think he said in his testimony was more complicated.
Exactly.
Difficult to read, and that's
Exactly
why
so.
Is that part of your
It's
position?
it's the evidence. That is the evidence. And every medical witness testified. That's why we allow orthopedists to rely on the report.
Let me ask a related question. You're probably familiar, although I don't think it was cited in the briefs in this case, with the Smethers case that Judge Winthrop wrote a few years ago, which held that a plaintiff who is cross-examining a defendant doctor's standard of care expert can ask him, okay, you
What
said
do
you
you
told
do?
us what the standard of care is, but what do you do?
Uh-huh.
Well, why isn't that sort of applicable here to plaintiff's expert?
It's not applicable because the issue of whether the film was correctly read is not an issue in this case. No one is claiming that the MRI film was incorrectly read, that the report was incorrect.
Well,
No
I
one's
thought
claiming
Dr.
that.
Williams was claiming that. He was saying if
Not against Dr. Ferguson.
well, I thought he was.
No, he's not, because he admitted that Dr. Ferguson could rely on the report. Dr. Ferguson didn't have to look at the film. He was fine to rely on the report, which said incomplete rupture.
So you're in essence saying, and I certainly see some logic to this, but you're in essence saying that the deposition testimony, where he acknowledged in as I recall, a 3 or 4 question and answer sequence, that the orthopedic surgeon is entitled to rely on the report, that narrows any prior or subsequent disclosure of something more. Is that what you're arguing?
No, because he testified to that at trial. It doesn't really, the deposition testimony didn't come in at trial. What we're concerned here with is the trial testimony. And what he testified at trial, what was not disclosed, and really this isn't, it's more of an irrelevance issue than a non-disclosure issue, but it's both. What wasn't disclosed was any theory that the film was misread, that the report was wrong, that the film, that Dr. Ferguson should have looked at the film, and if he had done so, he would have seen a complete tear. No one said he should have looked at the film. Everyone said he was right to rely on the report. So if he didn't have to look at the film to meet the standard of care, why do we care what Dr. Williams said the film would have shown? Dr. Ferguson didn't look at the film, and he didn't have to.
Well, to try to answer your question, which we probably shouldn't do, but
Sorry.
I'll try it anyway.
I'm not in the habit of asking judges questions.
Maybe it's Dr. Williams' overall opinion that ordinarily, without some special circumstance, the orthopedic surgeon may appropriately rely on the report. But
He said that.
But here, Dr. Williams, I get the feeling, is saying, but here I've got some other information. I've got what I consider an ambiguity in the report, and therefore I think he should have followed up more. And one of the things he should have done was to look at the films.
He thinks, he did not say that one of the things to do to follow up was that Dr. Ferguson should have read the film.
Was he precluded?
He was not precluded. He said, yes, he should follow up because to me this report is ambiguous. Dr. Hartzler said, to me this report is not ambiguous. It meets with the physical. So it's ambiguous, it's not ambiguous. Dr. Williams did not say Ferguson should have looked at the film. He didn't say that. No one said that.
What before we lose you here at the time,
Yeah.
what exactly is your understanding, after having studied this obviously quite a lot, of the basis for the trial court's ruling?
It's irrelevant because no one complained that the film was misread. It was not disclosed because there's no theory that the film was incorrectly read. So it's irrelevant and not disclosed. And also, Dr. Williams can't testify that Dr. Kavanaugh incorrectly read the film because he's not a radiologist like Dr. Kavanaugh.
Could he testify, if it was otherwise relevant, to his own opinion as an orthopedic surgeon, that I read it this way?
That wasn't relevant. It was still not relevant because no one said Dr. Ferguson should have read the film. No one said he should have.
Okay, thank you.
I apologize, I'm out of time to address any other issues, but if you have questions, I'd be happy to answer them.
May I ask one more?
Sure, you can ask one.
What was anything stricken from the record other than a disclosure statement that you recall?
Yes, I have the order in front of me. It was the 6th supplemental disclosure statement, and there was the deposition transcript it was probably Williams, These were attached to the reply brief. And the order's dated November 12th, 2014,
Okay,
from this court.
thank you.
Thank you, Your Honor.
Thank you. Mr. Lloyd.
Just briefly, I think if you look at the record, you'll see that the only issue raised by defense counsel with the court, or with the trial court, was, quote, "This is an attempt to bring in expert opinion on that radiology report, not through a radiologist. It's
What page
improper."
are you on? I've got it here.
Page
too.
17 of my opening brief.
Oh, okay, I have the transcript here.
Okay.
I thought you were reading from that.
Oh.
Go ahead.
And that was the only issue raised, and it was on that basis that the court precluded Dr. Williams from making his offering his opinions. And again, it's not whether or not Dr. Williams or where Dr. Ferguson should have read the images. He was supposed to read the report. He didn't read the report. If he had read the report, as Dr. Williams explained, there's a clear ambiguity in it. That would have triggered a response. That response would have led to further investigation, including reading the images, including, then, as Dr. Williams did, discovering that there was a total, complete biceps tendon rupture.
I don't mean to be argumentative
Okay.
this afternoon, but since I've argued with Ms. Gilbride, I need to argue a little bit with you. It seems to me that it's a fact question, whether he read the report, whether it was read to him, whether that adhered to the standard of care, and the jury could have gone either way on those. And so, to the extent your argument is founded on he didn't read the report, well, that's just a fact question that the jury apparently found against you.
Correct. That is
You've got to have something more than that. don't
It's
you?
a fact question, but what we had more than that was Dr. Williams's opinions that if he had done what he was supposed to have done, he would have discovered it was a complete rupture, and then he would have taken him to surgery.
So
That's the issue.
What is it that you claim Dr. Williams would have said that he was supposed to have done?
It wouldn't have been what he said. He would have shown to the jury the films that were blown up this big, a series of slides off the MRI, clearly showing and just commenting on the evidence. He was going to be commenting on the evidence. Look at this slide, and now you can see where the muscle or the tendon is off of the bone.
And
But
that was disclosed?
Yeah.
And where was that disclosed?
In his deposition, he said,
That's not in the record.
yeah, it's in his
Ms. Gilbride just said that's been stricken.
no, in his deposition, he testified to that.
That's part of the record?
Yes.
He said in those many words, he said, he said, I've looked at the MRI films.
And I believe
they
it's
were
a-
wrong, and they were wrong.
I looked at them, no.
I mean, the report was wrong. The report was wrong because it was
No,
a complete.
he's not even saying that the report's wrong. He's saying the report's ambiguous. He can't tell what that report means. Because,
Didn't the report suggested a partial tear? And he's going to disagree with that.
right, because the first part says it's a rupture. Well, in orthopedic terms, a rupture means a total rupture. And then it says it's an incomplete rupture, which is a little inconsistent. Then it goes back and says it's got a circuitous route. And so he said that would have triggered some sort of a response. And if he had done that, and as I said, the images were in evidence, he would have, Dr. Williams was prepared to show the jury exactly where that tear was, commenting on the evidence, on his opinion of it, and he wasn't permitted to do that. I'm out of time too. But.
Thank you for arranging your schedule so we could have the argument this afternoon. We appreciate that. Thank you for the argument. We will take this matter under advisement and issue a written ruling in due course. We stand adjourned.